Hello, Chris. How are you?
Hi, I'm well. How are you?
I'm fine, thank you, and happy to see you and to have you as my guest here today for this interview, this Wicked interview, where we're actually going to be talking about a paper that you recently wrote and that was published. And it's a very interesting paper about a specific topic. It's on bail. And specifically about Gladue principles in section 493.2 paragraph A of the criminal code that talks about Gladue principles in the bail context. And before we start talking about that, I do want to mention that we do have a conference on bail that's coming up on September 12th, and you're actually going to be one of our speakers. So we were very happy and excited about that. And this is actually a very good opportunity for you to start talking about bail for people who are registered or who are interested in the conference. They'll get to hear, that's like a preview, to hear a bit from you about what some of the things that you're going to be talking about. But before we do that, Chris, if you can just introduce yourself. I know a lot of people know who you are already, but if you can just give us a brief introduction about who you are and what you do.
Sure. My name is Chris Rudnicki. I'm a lawyer. I was called in June 2015, so about 9 years ago now. I practice at my own law firm, Rudnicki and Company, and I practice exclusively criminal defense with a focus on criminal appeals. I'm also sort of what you might call a casual academic. I do some part-time teaching at TMU, the new law school at Toronto Metropolitan University. And I also write quite a bit. I've published quite a few papers, including this one on Indigenous Pre-trial Detention.
And so let me just give the full title of this one so that for people who
Sure.
haven't read it, they will be able, and they can find it online. I mean, it's available. It's Proportionality as Constraint on Indigenous Pre-trial Detention, Realizing the Remedial Potential of Section 493.2, paragraph A. And this is by you, Chris Rudnicki. So, Chris, I'll let you then start talking about this paper.
Sure. Thanks. And thanks again for having me. It's a real pleasure to be on, a long time watcher of the program, and delighted to sort of join the guests who shared their wisdom with you folks. I wrote this paper because I was trying to get my head around how 493.2 changed things in the law of bail. I mean, so it was passed in 2019. And so in 2019, I had been practicing for a few years at that point, and I knew that Gladue was already relevant to bail principles. Jill Rogan, who's an academic at the University of Windsor, had written a lovely paper about how to kind of wrap our heads around bail before 493.2 came out. And so my purpose with this paper was to understand how things might have changed. And what I came up with was a sort of two-part framework for looking at 493.2. The first is what's called the corrective component, which is aimed at correcting biases and assumptions about Indigenous persons, both on the part of the decision maker, but also in terms of the sort of social context that Indigenous persons face in the broader public before they ever enter the bail system. Discrimination in housing, discrimination in employment, discrimination in access to services, of course, deprivation of access to lands and practices and so on, all of which might sort of result in disadvantage in the bail system. And the corrective component is aimed at sort of making sure that we don't, that decision makers don't improperly infer risk on either the primary grounds or the secondary grounds because of those factors. So to give a concrete example, let's say an Indigenous person comes before the court with some fail to complies on their criminal record, and those fail to complies are related to an alcohol use disorder. Well, the corrective component would say that those fail to complies don't necessarily indicate a disregard for court orders or disrespect for the court system, but instead reflect a substance use disorder that itself stems from systemic factors that the Indigenous person faces in the community. So what otherwise might be a sort of knock against them on the secondary ground is kind of neutralized by this corrective component. So that's the first component of what I say is the framework for 493.2. And it existed, that's the old law. That existed before 2019. That existed before 493.2 came into effect. And my thought was, we can't have intended to do things as usual. Parliament can't have intended to do things as usual with 493.2, because if they did, they wouldn't have passed it, right? They wanted to enact a provision. If you look at the Hansard and the comments put on the record by the various ministers who spoke in favor of the bill, they wanted to do something to get at the crisis of Indigenous over-incarceration in our system, which was bad when Gladue came out in 1999, worse when IPELA came out in 2012, and worse still today. And so Parliament's trying to really add tools to the toolbox to try and get at this problem. And so what can we do in addition to the corrective component? I came up with what I call the remedial component, the second component of 493.2, which is intended to achieve this remedial purpose of sending less Indigenous people to jail. And the way it does that is by by sort of using proportionality as a constraint on Indigenous detention. So the test to apply is detention is only justified where it's a proportionate response to the risks posed by this particular defendant on the primary and secondary grounds. I try and plug this factor, this remedial component, into the case law on sort of time served positions that comes from a series of cases both called White. One is a trial decision from Justice Hill called White. One's a Court of Appeal decision from Justice Tulloch called White. And then Myers, the well-known Supreme Court decision on 90-day detention reviews. Those cases all say that where somebody who is detained pending their trial reaches what could reasonably be said to be a time-served position, regardless of whether they pose a risk under the primary or secondary grounds, they should still be released under the tertiary grounds. Because to detain somebody who's already served the equivalent of a fit sentence would undermine rather than preserve public confidence in the administration of justice. And so I take that same kind of logic and apply it to Indigenous defendants and say that, well, so in the context of the crisis of mass Indigenous over-incarceration, and in the context of what we know to be a very sort of non-carceral focus of Indigenous sentencing, when we look at this particular defendant, is detention a proportionate response to the risks that they pose under the primary and secondary grounds? And so for somebody who's charged with an offense that may well be eligible for a conditional sentence, particularly since Bill C-5 in 2022 brought back the CSO for a host of offenses where it was previously not eligible. If somebody comes before the court who's eligible for a CSO, and their risk, maybe they have some risks under the primary or secondary grounds, the sort of those sort of hypothetical risks under the flight risks or safety risks might be outweighed by the certain cost of detaining them before their trial. That's basically the thesis of the paper. That sort of turn of phrase, that hypothetical risk can be outweighed by a certain cost, comes from Justice Pomerantz, who's a wonderful judge in Southwest Ontario, now the RSJ of that region, in a case called Elliott, where she essentially says that same thing. And the hope is that this paper will sort of put tools in the hands of advocates and of decision makers who are interested in reducing Indigenous over-incarceration, to give them an analytical framework to understand how, even though someone comes before the court and maybe they don't have the best plan of release, maybe they don't have a fantastic surety, maybe their surety themselves is Indigenous and has a criminal record. And maybe so there's some risks under the primary ground, there's some risks under the secondary ground. This paper is aimed at giving decision makers a framework to release that person nonetheless into the community.
Yes, and because you do also mention in the paper that we still have, unfortunately, a lot of Indigenous people who are still incarcerated, and there's an overrepresentation of this population. And so the question here becomes, so I know that you're trying to help here, you're providing a framework and an interpretation of the legislation, reminding the courts and everybody who's involved, who gets involved in bail, of this section that is important. But the reality is we don't really see this section and these principles being applied. And that's what's becoming frustrating in bail courts, is that we have laws, we have the section now codified that it doesn't necessarily introduce something radically new. It was part of the law, but maybe now it's specifically stated in the context of bail. But still, it doesn't seem like these principles are fully being applied. And you do actually mention something interesting, that Parliament gives us this section, but it doesn't tell us how to implement and how to.
Just like with 718.2, right? It took the
Exactly.
Supreme Court 2 trials
Right.
to articulate that.
But then, like, what can we do here, Chris, to, like, I know you're doing this here with the paper, but again, like, how do we translate this into the reality of everyday bail courts? Because we're still not seeing that being fully implemented.
Yeah, certainly there's a huge cultural competence problem on the part of decision makers. We're lucky to, well, I'm lucky to practice in Toronto, where there's a lot of really sympathetic judges who understand these issues and who are keen to try and do their part to reduce this problem. And there are other jurisdictions where judges are, shall we say, less keen. Systemic racism continues to be a problem, and that infects decision making at every level, unfortunately, of the court system, from the police all the way up to the judiciary, including the Crown's office, and including, unfortunately, some defense lawyers. So we have to, projects like this, exactly like the one you're engaged in with your education program, I think are really important for spreading the word about the problem of Indigenous over-incarceration, helping folks to understand the history of colonization, the history of dispossession, and how that's led to these material conditions of poverty, of addiction, of lateral violence that cause people to come before the courts, and how the appropriate response isn't to simply lock them up and throw away the key, but to try and take active steps to connect people with the appropriate supports in order to protect the public, but also to rehabilitate the individual. And we can start that, I guess, at the bail phase with 493.2. In terms of like what we as defense lawyers can do,
yes,
I have literally made this exact submission in bail court for an Indigenous client and explained, well, here's exactly, because my paper is designed not to sort of be like, here's all these social science articles that you could use. It's case law, right? It's binding precedent that I hope will persuade your jurist that we're right about the corrective component and the remedial component. We're right about Parliament saying in 2019 that it's time to do something different. And that should militate on the specific facts of your case, which of course you'll have to marshal whatever resources you have in order to make your pitch. But persuade your decision maker that release is the right result.
And although, I mean, the paper is mostly focused on paragraph A, which specifically deals with Indigenous individuals, but I mean, the same argument could be made for other groups, minority groups, right? Like for Black accused or Muslims, or from any other groups that we see represented often for the courts. So the same reasoning applies. So there's, I want to go back to one of the points that you did mention, and it's about the time served, because you do use this example of an individual on the tertiary ground, that if an individual now is detained and has been in custody for a while now before their trial, and it's almost going to be a time served situation. So then on the tertiary ground, that could be something where you can lose confidence in the administration of justice, because, what's the justification at that point if they're going to end up serving more than what the sentence is actually going to be. But in cases, though, where we're not at time served, where there's still going to be a lot more left, so how can you use that to your advantage?
Yeah, two points. One is that time served shouldn't be just a sort of like have we yet reached now today the point of time served? It's prospective. So knowing that we're looking at a year or 2 years at least for a trial to take place in most jurisdictions. Is it likely that this defendant charged with these offenses would reach time served at some point before the trial? And so I think the sort of immediate advantage of this framework is saying, like, anybody charged with like a fail to comply or a low-level assault or an impaired driving offense or anything that's sort of, we know they're not going to get jail or they're going to get short sharp sort of at the most, that person gets out, even if they don't have a good plan. Because to detain them for a year prior to their trial would be outrageous. So that's the sort of immediate, I think, advantage of the framework. But for people who are unlikely to reach a time served position before the trial, I mean, that's a person you're going to have to think a lot more carefully about. But my understanding of the numbers behind Indigenous over incarceration is that they tend to be driven not by murders or serious sexual assaults or serious firearms or drugs cases, but by low-level, failed-to-comply administration of justice offenses. The Crown's office has not gotten the message around these judicial revocation hearings that are supposed to be available for failed to complies. And in my experience, they're simply charging, they're simply prosecuting failed to complies, and they're seeking jail sentences. And if the client has a history of failing to comply, they're seeking detention at the bail stage. And again, the advantage of this framework, I think, is to make the pitch that, listen, if this person's only going to get, if the Crown's position on the screening form is 30 days, that's like automatic, you should get out on your own recognizance with no conditions. Because to say, no, I'm not taking the plea deal, I'm going to trial, if you're detained pending your trial, then you're going to reach time served, months and months, if not years before the trial date. And as I say in the paper, I think that undermines rather than preserves public confidence in the administration of justice.
But also, Chris, don't you think that one of the problems that we have in bail right now is what is a good plan? I mean, in Ontario, a good plan is almost always a surety. Sometimes the more, the better. And the problem here is that for many accused, and this is something that we're going to be talking about actually at the conference, the bail conference. But I mean, the problem here sometimes is some people don't have anyone who's going to be acting as a surety, or they did have someone in the past, they're not available anymore. So the whole idea of what a good plan isn't that also a problem, that it's always a surety and money sometimes? And if you don't have that, then there's no point of getting released, or there's no hope, like you're just going to be detained. But that is wrong. I mean, that's not what bail is about. It's not just about having a surety. I mean, there are other ways you can address the concerns, right? I mean, isn't that also part of the problem?
I totally agree. And I think this is where the corrective component comes in, because one of the things that happens, like one of the consequences we know that flows from systemic discrimination against Indigenous people is family dislocation. And are these circumstances where you have someone who comes before the court who's not got a surety, who can't have it, who no one is either willing or able to come forward to be their surety. But I think that it's a mistake to conflate the absence of a surety with the absence of a good plan. You could put together, I think, even with no sureties, a plan of release, which is, here's where my client's going to stay, here are the supports they're going to access in the community, here's what they want to do with their freedom. If I were making this pitch to a jurist, I would say that's the plan of release, and it doesn't require a surety, as the Supreme Court has said many times now, most I think recently in Antic, that a surety is not synonymous with a good plan of release. What matters is whether the plan addresses any concerns under the primary and secondary grounds. And just because my client maybe is unhoused, because my client isn't able to abide by a curfew or a house arrest condition, doesn't mean they don't have a good plan of release that gets at risk to the community. Right.
And how do we get to that change in culture, though? I mean, other than, like it's something that's not going to happen. I mean, we do have like this section that you're highlighting in this paper. It does help, right? Because I mean, this is in the code. You can just simply refer to the fact that we have this in the code. There's this framework that you're giving, can cite your paper. But I mean, as we know, the reality is it doesn't really happen overnight. I mean, before section 493.2, we still have section 718.2 in the sentencing context, but we still have that problem. So maybe it's starting to change a little bit, and judges are still taking that into consideration. But we still have this frustrating part where in decisions, we'll see judges or JPs, they'll say, I did take into account this section, but I still think so. It's kind of frustrating because even if you bring these principles to light, they'll just find a way to say, yeah, I took that into account, but still I disagree. But it doesn't seem like it's like, what else needs to happen? Like, how can we just you know, like it's frustrating in the reality of courts.
I totally agree. I mean, my paper is, I mean, I should be clear that my paper does not say that every time an Indigenous person is charged with a criminal offense that they should be released on bail. It simply says, here's a framework for sort of rejigging the way we look at Indigenous detention, to think of proportionality as the sort of operating guiding principle, rather than simply sort of like a mechanical reading of the 3 grounds for detention in section 515 of the criminal code. So there will be cases where a jurist properly considers the remedial component and the corrective component and comes to the conclusion that detention is proportionate. You know, and a good example would be a murder case where there's a very strong Crown case. So even with supports in the community and a plan on the primary and secondary grounds, that person would likely be detained, regardless of the application of the corrective or the remedial component. So in that sense, the paper works within the system that we have, and the system is flawed. The system is not perfect. It's the product of a settler colonial state that was founded by the British and the French with the intention of extracting resources from Canada for the purpose of enriching European investors. That's the point of Canada, and that's not going to unfortunately, the consequence of that history is not going to be fixed by a sort of application of a legal test in a courtroom. So I suppose the sort of pithy answer to your question is that the problem of Indigenous over-incarceration is complex and has historical and contemporary factors that are ongoing, and we're simply not going to fix it in the courtrooms. But we can try to do justice in individual cases. And where there's a justice of the peace or like an initial sort of first instance bail justice who we say fails to grasp the significance of 493.2 and fails to appreciate the both the corrective and remedial components of the test. Hopefully we can fix it on review. You can go to the Superior Court, and you can try and get a Superior Court judge to weigh in.
And I wonder also if judges or JPs who are doing bails in the first instance are fully aware of the conditions in the jails. I mean, sometimes it is important also to bring to the attention, because not a lot of people know what really happens, like the lockdowns, for example, how difficult it is for clients to prepare for their cases, sometimes to even communicate with their lawyers because of issues at the jail, the conditions that they have to live in, the fact that it's very difficult for their families to call, they have to be put on lists and get approval before they can have communication with them. So, I mean, I wonder also to what extent, is this something that defense lawyers need to raise more and just put the spotlight on how, and of course, not all institutions are as bad as others, but there are some institutions that are really very, have very harsh conditions where even it's difficult for lawyers to even communicate with their clients. So is this something that should be brought up in bail hearings every time, that if this person's going to be detained, this is what's going to happen, or there's no point in raising that?
No, I think it's an excellent point, an important point for sure. That is, I would say that the harsh conditions of pretrial confinement are absolutely a proper consideration in assessing the proportionality of detention.
Right.
If somebody's going to spend their pretrial confinement in an institution that has programming and community visits and access to good health care and access to physical activity and so on, appropriate supports, that's a very different picture of pretrial detention than somebody who's going to be in lockdown 5 days out of the week and who's not going to have any access to counseling or faith supports or any kind of recreation other than sort of, the criminogenic factors that we know come with harsh conditions of pretrial confinement. There's a lot of wonderful decisions out there now in Ontario and Toronto in particular on those issues. A recent decision from Justice Jones, who's co-organizing the conference with you, in Nanabush comes to mind. And so I think council now could safely, it depends on the jurisdiction, of course, but I think there are definitely jurisdictions where council can safely file case law and simply say, take judicial notice of the conditions of confinement. But if you don't have, as defense counsel, if you don't have that case law to rely on, then you may need to call evidence, and that evidence may have to come from your client. Always a risk to put your
Yeah.
client on the stand at the bail hearing, or maybe it can come from a jail worker, like if there's a social worker who's in the jail who's able to speak to those circumstances, or maybe another lawyer who can come in. Hearsay, remember, is admissible at a bail hearing. And so, one of the things that was really powerful during the pandemic was that there was this doctor's affidavit floating around talking about the risks of contracting COVID-19 in congregate living facilities. That same kind of resource could exist sort of in every jurisdiction where there's a jail. Of course, it have to be updated from time to time, but that would give the judge a tool to be able to understand what it's going to be like. Although my experience is that, most judges know, they know what it's like in their local jails, and they know that it's awful. But it's still, as I said, I think it is an important part. It's an important part of the picture when it comes to deciding proportionality of pretrial detention.
Yes. And the reality as well is that for many, especially if we're dealing with a case where the individual is facing serious charges, I mean, it's not like they're going to be released to live a normal life. They're going to be released on very strict
conditions. Exactly. We're not talking about an acquittal here, right? We're talking about release into the community pending the adjudication of their trial.
Exactly.
And if they're convicted, they will get a sentence, right? They will receive a sentence that considers protection of the public, that considers all of this other stuff. Yeah, and that's a super important point. I totally agree.
Yeah, I mean, like many of them are going to be like, especially if we're dealing with a repeat offender, they're going to be released many times on house arrest, so they're not allowed to leave the house except in very limited circumstances. Some of them will have ankle bracelets, so it's really as if they're still sent and they're still jailed, but in the community. So it is also something that needs to be reinforced, that it's not bail. Bail doesn't mean that they're going to be living a normal life. Their lives are still going to be very limited. Their freedoms and liberties are limited pending their trial or eventually their guilty plea. But again, I mean, another important point that we still need to, I mean, I know we know this as criminal lawyers, but it is, I mean, the importance of actually having your client released for bail. I mean, sometimes as defense lawyers, we understand how important it is, not just because it allows us to prepare better with our clients, but it is important for like to remind people the importance of having bail before a trial. If we can talk a bit more about that, Chris, and why we insist so much on having our clients released before their trials.
Well, I mean, it produces guilty pleas.
Right.
There's no question about it. That pretrial detention makes people plead guilty to get out.
Yeah.
And that's why I say the sort of immediate benefit of adopting the remedial component is that every time you have a client come up in bail court and the screening, the sort of bail crown says, well, if they plead today, they can get out. That person should take that screening form, go to the justice of the peace and say, this person ought to be released immediately on no conditions, because the Crown agrees they're in a fit sentence is the time that they've already served. So I think that's, for me, one of the most important takeaways is that if you're producing guilty pleas, not because someone is prepared to take responsibility for what they've done and wanting to make amends to any victims and so on, but because they simply want to get out of jail, that's not just on anyone's version of justice, right? We know it produces wrongful convictions, or people plead guilty not because they did the crime, but just because they want to get out as quickly as they can. So I mean, I think that's the most important point. The other important point is that with the right supports in place, with the right plan in place, people come to sentencing in a very different position. It's one thing to have been in jail for a year or 2 years, having maybe had the opportunity to complete a few sort of small programs that are on offer, but otherwise having kind of stalled in one's life for that time, versus somebody who's been in the community, who's been able to access robust supports, who's done sort of more robust courses of counseling, or who have engaged in much stronger supports from their family or for their loved ones who maybe have had the opportunity to go to school and complete their schooling or to go back to work, and again, just be pro-social and rehabilitate and reconnect in those years. It makes a huge difference at the sentencing phase. A judge is far more likely to say, let's give this person a community or a non-custodial sentence if they're sort of faced that picture, versus someone who comes before them having served only a year in jail and with like nothing really much more to say about it, except that, you know, the conditions were quite harsh. The judge is likely not to give much of a discount in that kind of a scenario.
And this is a very important point here that you're making, because, I mean, it is important to look at what the individual is doing prior to sentencing. If we do end up getting to a stage where sentencing is going to happen, and the judge almost always looks at what they've been doing just before they got to sentencing. So for someone who's in detention, sometimes even, let's say they do want to participate and do programs, sometimes there's a language barrier. They can't do many things because they don't speak the language. So you're kind of discriminating against these individuals because some of them have the willingness, but I have clients who say, well, I can't really do much. I don't speak English. So, I mean, I just don't know that people realize how frustrating it is for vulnerable groups and minority groups, that it's very nice to say, well, why didn't they do this? Why didn't your client do that? Well, sometimes they do want to do all these things, but they can't. Like, so
it's not available. Yeah.
But we're penalizing them, right? Like when we just say, well, it was up to your client to do something. But the reality is they don't have.
If they don't speak English, and or they only speak a little English, if their first language is Arabic or Spanish or anything else, right? Like it's a huge disadvantage. And I think actually it's a wonderful point you've raised. There's actually a case from the 90s called FA. It's from the trial decision in 94 and a 96 Court of Appeal decision. I think it's in my paper. If it's not, people can reach out to me and I can send it to them. That talks about language barriers in prison, and talks about how you know, somebody who doesn't speak the language of the correctional authorities is going to have a much harsher experience of imprisonment. In FA, it was an Indigenous person who spoke only the language of their community and did not speak English. And the judge said, well, I'm not going to send them to, that would be absurd to send them to the penitentiary where they're not going to be able to, like, it's all about rehabilitation, but how can they rehabilitate when they don't speak the language of the programs? And I think that same point could be made in the bail context with 493.2 sub B, because that's about vulnerable communities. And I think that folks who don't speak English well fall squarely within the four corners of that provision.
Yeah, because like the discrimination continues even in the pre-trial detention phase. We're not giving them the same opportunities that other people who are in detention could have. And it's unfair then to say, well, they didn't do anything. They didn't show any kind of rehabilitative prospect. So it's sad. I mean, I know it looks like a little bit depressing that it doesn't seem like there is a solution, but I think one thing that I do want to end on here, Chris, is what would you say or give advice to defense lawyers? Because it seems like it's all the work, the bulk of the work has to come from the defense. Like it really, this cultural change and this awareness as to how bad the situation is has to come from defense lawyers. So what would you tell, like, I know I would tell everyone to read your paper and to maybe use that as a framework, but what other tips do you give for defense lawyers here for the bail stage who are dealing with difficult situations for clients?
Yeah, I don't want to let Crowns off the hook. I know Crowns watch the series, and I think that they need to attend very carefully to their own bias in deciding questions of release, and they should be consenting far more often than they are. I think that's as a preliminary matter, I want to say that. But for defense counsel, I would say, you know, really, I would echo the sort of point that my old professor David Tanovich makes all the time, which is that it is our, you know, the material reality of the situation is faced with an unfriendly or ignorant crown or judge. It's our obligation to do the education. Like we've got to get out there and teach them. These are the consequences, the material consequences of colonization. Excuse me. These are the material consequences in my client's life. This is what it looked like for them to experience collateral violence and addiction and so on. And here's what the law says about how we have to respond to it, and here's why that should compel release on these facts, and which requires a lot more work.
Yeah.
Like we're going to have to do a lot more work. You may not, you're unlikely to have a Gladue report at the bail juncture, but it's just the part of the job. You just have to do that additional work to do the education, and that education will pay dividends, because once the judge learns it in one case, they'll start to apply it themselves.
That's correct.
In other cases, and Crowns, same thing with them.
Yeah, that's right. Well, what I will say is I strongly recommend that people read your paper. It's very easy to read, and it's excellent, and it really has some very interesting and important points that I think that I'm actually going to be relying on, because it's really very useful. And again, even though the focus is on paragraph A, but the same logic applies, I would say, to other groups. So it's not just for Indigenous. It's an excellent paper, and you can find it online. I was able to find it just by a simple Google search. So thank you so much, Chris, for taking the time to talk about this paper. I'm happy we're going to get to hear more from you at the bail conference. And we'll be happy to have you again as a guest. Hopefully, if you have more papers, I'm happy to interview you again about them. So thank you so much for your time today.
A pleasure. Thank you. Thank you for having me. I appreciate it.
Thank you.